couple of questions. I see in the bill about the public servant, and it's safe to assume the public servant definition will include police officers? Is that
yes. Yes.
Okay. So,
and elected officials, Mr. Reilly.
Go ahead.
And elected officials as well.
Okay. So if you have an undercover police officer who's testifying in a grand jury and there was no true bill and someone puts in a request, will the undercover police officer's name be divulged to the public?
No.
Is there anything in the bill that precludes or actually codifies that to ensure?
The language says the court, after they find the three-part test that I previously mentioned, that even if he meets that test, the court can still limit partial or even full disclosure if they find a reasonable likelihood that the disclosure will endanger, identify a witness or a grand juror, or jeopardize public safety, or is in the contrary to the interests of justice. So if a court makes a determination that the name of a public servant who was undercover should not be released, it will not be released.
Okay, thank you. So
you're welcome.
In regards to my colleague who spoke before me and gave the example of two individuals, A and B, if, say, individual A was a star, whether it's a singing performer, movie star, and they testified in a grand jury and they were a victim, and say someone who is a dear fan puts in a request, would that satisfy the three-pronged test that you mentioned?
I have not now, nor have I ever aspired to be a judge. And I'd be very blunt that conversations and questions about celebrities being threatened is not very pleasant to me or my family. However, I hardly think that that would meet the test that a significant number of members of the general public are likely aware of it, or that creates public interest. And even if it did, the information would be redacted in the case for somebody who is living, as my family did for a number of years, with death threats.
Mr. O'Donnell, I want to clarify. That question that I asked had nothing to do with anything personal. It's actually, I was relating it to a case that I actually worked on in 1999 in Midtown, and it involved a rap performer and a movie star. So that's what I was relating to. So I
apologize. I was not questioning your motives, sir. I was just informing you that I've lived my life with a celebrity in it and have lived with the downside of what that means, which includes living with a death threat for a number of months.
And I appreciate that. And just for clarification, as a former police officer, I actually had death threats against me as well, and some of my colleagues, which was documented due to cases that I was involved in. But I have a couple more questions. Okay. Is there anything in the law, in the current existing law, that allows grand jury minutes and testimony to be publicly viewed after a judge renders a decision?
Recently in Rochester, the case out of Rochester, which was prosecuted by the Attorney General Tish James, she went to the court and asked for the grand jury minutes to be released, and they agreed to do so.
So in essence, there already is a mechanism in place that provides transparency for those that may be interested in finding that information.
I don't believe so, because I wrote this law after the Eric Garner case. And the Eric Garner case, after he testified in the grand jury, the police officer involved only had two things to say. I didn't intend to hurt him. I didn't intend to hurt him. And as a criminal defense lawyer, I knew very well what that meant. That meant that the ADA in that room did not tell the grand jurors that you could indict someone in a homicide-related matter without intending to harm them. And so it seemed to me at the time that public servants, district attorneys who are elected like you or I, have an obligation to do justice. And that includes giving the options that are appropriate to a grand jury. And I'm fairly certain in that case they did not do that.
Okay, so just stepping back a little bit to the answer that you gave me about the case in Rochester, my question was, is there any mechanism in place in the laws today, currently, that allow that information to be provided? And if I'm not mistaken, your answer was the Attorney General applied for a motion and was granted that motion by a judge in New York State. Is that correct?
Yes, but in that case, the Attorney General was the prosecutor. So I'm not sure that anybody else but the prosecutor would have been allowed to make that motion. My bill allows anyone to make the motion, and if they meet the standard, they are entitled to that information.
So under this law, under this bill, if enacted, the local media, if the case has significant presence in the community or concern in the community, the media can be included in the applicant process.
Yes, that's the purpose. The purpose is to allow the greater public to know what happens inside a grand jury when what the general public knows about the case from the media seems to contradict the conclusion of the grand jury.
So how many, just for clarification for those who may not know, do you know how many people sit on a grand jury? How many
My
citizens?
recollection was it was between 18 and 24. Is that correct?
Yeah, I think so. Yeah, so 18.
Okay.
So we have, let's take for instance, we have 23 members on a grand jury. They're presented the evidence, the circumstances surrounding the case, and they're given the charges that are being presented, and they render either a true bill or no true bill, which means that there's no probable cause to continue through trial, correct?
But they could also issue a misdemeanor charge, a prosecutor's information. Yes, that's correct.
Okay. So the issue this bill is addressing is the fact that there's no true bill, no indictment, so then a criminal prosecution won't continue?
I'm sorry, I didn't follow you. Can you ask that again?
What your bill is trying to rectify is the fact that the grand jury decided, after deliberating the case that was presented before them, they decided that there was no probable cause, so that a trial will not commence. And you think this bill would present the fact that you think the grand jurors were wrong. Is that correct?
No. My guess is the district attorney was wrong. The district attorney, the ADA in the room, either threw the case or didn't put enough evidence in or didn't give them the options that were available to them. And since the DA, like you and me, are elected, the people who elect her or him should be entitled to know what they did in that room that resulted in the case being dismissed. And sometimes now that case, the primary witness is a videotape that we all saw over and over again.
I understand. I recall the video, and you know, it was very tragic to watch. It was very hard to watch, but of course there in the specific case you're talking about, but there's always other factors around, and in no way am I downplaying the severity of the incident. What I would like to clarify, though, is if this is targeting prosecutors, assistant district attorneys, or district attorneys themselves, why wouldn't the bill be concise to ask for prosecutors to be more transparent about the charges they present in a specific case in a grand jury, and not even give the possibility of endangering witnesses that testify in a grand jury? Wouldn't that be more suffice if the overall arching goal is to ensure that prosecutors are doing what they're supposed to do?
That's a great question, sir. And if somebody had asked me to explain the bill and how it got here, I would have done that. This is two bills that have been amalgamated into one. The first bill was written by Carl Hastie, our speaker, before he was elected speaker, and our body passed it. That had to do with disclosing the testimony of certain people. My bill, which was written after the Eric Garner case, was only about disclosing to the public what the charges were and what the district attorney told the grand jurors. Those two bills will merge into one, but they are very clear about the fact that they can limit disclosure, full or partial, if there's a reasonable likelihood that it will endanger, identify a witness, or create a threat to public safety. So that exists, and that loophole is so large that a judge can make a determination that that's the case.
Thank you, Mr. O'Donnell.
It's my pleasure.
Mr. Speaker, on the bill?
On the bill, sir.
So what I'm hearing throughout the debate is that we're going to give judges judicial discretion over what gets released in a grand jury case. That does not render a true bill. It is ironic that we pick and choose when we want to give judges judicial discretion. We don't give judicial discretion when it comes to bail. And this is all about criminal justice reform. Well, this is about a level playing field. But who is really getting the level playing field? It is a targeted effect on certain individuals that we are looking to expose. Because why? Because we're not happy with what our fellow citizens swore to do in a grand jury. They are to evaluate the facts and circumstances before them. We can't pick and choose when we are going to say our fellow citizens did their civic duty when they serve on a grand jury. We should be thankful for them taking their responsibilities seriously. This will jeopardize the sanctity of the grand jury process, and I implore all my colleagues to vote no. Thank you.